Love Nation, this is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. We are now getting into part 6 of reading Justin B's lawyers filing, discussing Blake Lively's request for dismissal. And let me tell you guys, reading this document has been everything. There is a lot of information in here, and Justin's lawyers are not playing. Let's continue to read. And again, this is part 6. Section B. Section 47.1 does not apply to defamatory statements made by the Sloane parties or Reynolds or on Blake Lively's behalf. Furthermore, Section 47.1, by its plain language, does not apply to the defamatory statements made on her behalf by her co-conspirators and agents, the Sloane parties and Ryan Reynolds. For the purposes of Section 47.1, communication is defined as factual information related to an incident of SA, harassment, or discrimination experienced by the individual making the communication. Thus, the Sloane parties and Ryan Reynolds statements fall into an entirely different category than Blake Lively's own statements. Although not entitled to protection for the reasons discussed above, Lively's statements bear markers of baseline eligibility to the extent that they relate to Blake Lively's own experiences. In contrast, the statements of Sloane parties and Ryan Reynolds, which also purport to relate to the experiences of Blake Lively, were not made, as the statute requires, by the individual alleged to have experienced an incident of SA, harassment, or discrimination. And it does not extend to, and in fact is expressly drafted to exclude third-party communications, given their lack of protection under Section 47.1. It is not necessary to separately analyze malice or reasonableness, although the Sloane parties and Ryan Reynolds statements fall on both counts. Next section, 6. The fair report privilege does not apply. The fair report privilege renders privilege a fair and true report in or a communication to a public journal of A, judicial proceedings, or E, of a verified charge or complaint made by any person to a public official, upon which complaint a warrant has been issued. As Blake Lively acknowledges, the fair report privilege is typically invoked by the news media defendants in connection with publications concerning judicial proceedings. See this court case that they cited. However, the privilege also protects those who communicate information to the media. But the fair report privilege, by definition, only applies to communications relating to an official proceeding. So Blake Lively is forced to recategorize the allegations against her beyond recognition. In Blake Lively's telling, the defamation claim is based on her leaking the already filed CRD complaint to the New York Times, which subsequently published a fair and true report on its contents. This account diverges sharply from what is actually alleged in the FAC. As alleged, Blake Lively, Ryan Reynolds, and the Sloane parties started working with the New York Times months before the CRD complaint was filed. Indeed, the New York Times apparently started working on his story, fed by Blake Lively and her co-conspirators, as early as October of 2024. Blake Lively did not file her CRD complaint until December 20th of 2024. The crux of the FAC is that Blake Lively worked hand in glove with the New York Times throughout the fall of 2024, feeding his reporters defamatory statements and coordinating closely with them to ensure the end result would amount to a kill shot to the Wayfarer party's reputations and careers. This had nothing whatsoever to do with any then ongoing judicial proceeding. When the New York Times finally dropped its bombshell, multi-thousand-word feature nearly simultaneously with Blake Lively's request for a right to sue notice and its legally pointless sham attachment, plainly aimed at the public. It was after months of secret collaboration, during which Blake Lively and her co-conspirators made false and defamatory statements about the Wayfarer parties. At the time they were made, these statements bore no relation to any judicial proceedings, and they are therefore ineligible for the protections of a privilege predicated on the pendency of such proceedings. The fair report privilege does not protect Blake Lively, nor does Blake Lively address the defamatory statements made to those other than New York Times. These include those made by her agent and co-conspirators, Ryan Reynolds and Sloane parties, in the summer of 2024. As alleged in or around August of 2024, the Sloane parties made defamatory statements to the Daily Mail and other outlets to the effect that Justin B. is a predator who S.A. Blake Lively. Ryan Reynolds, on or at least two occasions in or around July of 2024, made statements to executives at WME to the effect that Justin B. is a predator and that WME was in business with a predator. These statements are even more attenuated from any judicial proceeding than those made to the New York Times, and they were made at Blake Lively's direction as part of a conspiracy to destroy the reputations and careers of the Wayfarer parties. Next, Section 7. The FAC alleges that Blake Lively acted with actual malice. As a matter of constitutional law, if the person defamed is a public figure, he must prove by clear and convincing evidence that the statement at issue was made by actual malice. Example, with knowledge that it was false or with reckless disregard of whether it was false or not. See court case cited. The Supreme Court has explained that while the concept of reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity, or must have entertained serious doubts as to the truth of his publication. See court case cited. There is compelling evidence that Blake Lively fabricated her accusations, was well aware that they were probably false, or at least entertained serious doubts as to the truth. See court case cited. Blake Lively's bald assertion that she believes her statements about the Wayfarer parties, which is at odds with the allegations in the FAC, carries little weight and is easily rebutted. Blake Lively's mere professions of good faith are not persuasive, especially where other mitigating factors are present. Defendants cannot automatically ensure a favorable verdict by testifying that she published with a belief that the statements were true. The finder of fact must determine whether the publication was indeed made in good faith. Actual malice may be proved by circumstantial evidence. Factors such as failure to investigate, anger and hostility, and reliance on unreliable or biased factors will create the inference that Blake Lively had serious doubts regarding the truth of her statement. Moreover, malice will be inferred if the defendant fabricated her story. It is the product of her imagination or is based wholly on unverified information. Blake Lively's motive for making the statements and whether she did so to harm the Wayfarer party are also relevant, as the allegations of harassment. Blake Lively clearly knew they were false at the time she made them because she was describing her own purported experiences, as outlined above and exhaustively detailed in the FAC. Blake Lively was not harassed on the set of the film, and she grossly mischaracterized or outright fabricated the events in question, even in sworn legal documents. Blake Lively and her co-conspirators engaged in a coordinated campaign to exaggerate benign interactions in service of a false narrative that Blake Lively had been SA'd. They did not so to instill terror in the Wayfarer parties and leverage it to accumulate power. This accumulation of power depended upon the ability to conjure and exploit ruinous allegations. The allegations were never true, and Blake Lively knew it full well. Blake Lively's insistence that she believed her allegations is, in addition to not being properly before the court on this motion, belied by the allegations in the FAC, the surrounding facts and circumstances, and the evidence already presented by Wayfarer parties. At a minimum, Blake Lively makes factual contentions properly reserved for the jury. Blake Lively also knew that the smear campaign narrative was false or acted with reckless disregard for the truth with her co-conspirators and agents. Blake Lively got hold of communications between the Wayfarer parties from Stephanie Jones that disproved the claim that Wayfarer parties had orchestrated a smear campaign. Given that she had these materials, Blake Lively either knew that the narrative she and her agents later publicized were false, or at best disregarded such evidence. It would also have been clear to Blake Lively, a longtime Hollywood fixture and the wife of a marketing company owner, that her negative publicity was precipitated by a series of off-putting public appearances and her puzzling decision to hawk adult spirits and hair products while promoting a film about DV. The fantastical notion that the backlash was caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. Taken collectively, the allegations in the FAC are more than sufficient to create an inference that Blake Lively acted with actual malice. That is enough at this juncture, even as the Wayfarer parties look forward to gathering more evidence and proving their case at trial. We will conclude this chapter right here, and we will continue with chapter 7 very shortly. Make sure you guys like, share, and subscribe. Share your comments respectively below. And until next time, be safe and enjoy your day. Bye, guys.